Good morning, Commissioner Dusan. Hi, the person who just joined named Tiffany. Can you let me know your last name and what case you're here for?
Hi, Tiffany's with the McHugh Law Office. I will ask her to. It's Daniel McHugh here.
Hi.
I'll ask her to log off. She's a paralegal.
It's fine if she's on there. I just want to know who's here. That's fine.
Okay. Is there a different public link versus the
There
Zoom
is.
link? Oh, okay.
Yeah, it's on our website, the link to the live stream that's going on YouTube that she could
Okay.
watch.
Okay. I'll forward that to the office then.
Okay. And we just posted it in the chat here for folks, the public access link. Hi, Mr. Galush. I see you're connecting. Hi, Alex. Good morning, Commissioners David and O'Brien.
Hello. How you doing?
Well, how are you?
Just fine.
Good. Good morning, Commissioner Ashby. Good morning, Commissioner Whitworth.
Good morning. How are you?
I am well. How are you?
Good.
Look at
Do we have,
all-
do
we
we have
have-
a chair?
That would be you.
Okay,
We do not have a permanent chair, so you are the most senior commissioner, so that would be you.
okay, thank you.
You should just assume that it's you, and I'll tell you if I hear otherwise.
Amy, is my microphone volume sufficient? I'm on a new headset and I wasn't sure if it was.
I can hear you fine.
Okay,
Commissioners,
okay.
can you hear Mr. David fine? Yeah,
Cool.
looks good.
Okay.
Thank you.
Thank you.
I think so. Thank you. What? Okay. Okay. Now or no more? Yeah.
Does anybody else hear that? I don't know if it's a squeaking or a bird. Barbara, thank you for confirming that I'm not imagining it. Thank you. That. Stop making that face, Barbara. I know you heard it.
It's 8:30. Shall we call to order?
Yep.
Okay, good morning. Gavel, gavel. I'm Deb Whitworth, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they're silenced now. We have made agendas available online, including the consent agenda. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission will vote on those cases and they will not be considered further today. The remaining cases on the agenda are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or written materials will be accepted today. In advance of that, we will adopt the agenda and consent agenda. Is there a motion to adopt?
So moved.
Second, Ed. All in favor? please raise
Deb,
your hand.
Deb,
Pardon
I
me.
have a question about the consent agenda that it contains the McDonald case, which is also on the litigation and the same docket number.
Yes, I'm happy to explain why that is. There were 2 proposed findings that were reasonable grounds and 3
Right.
proposed findings that were no reasonable grounds. So it really just splits up the claims. So what you have
Okay.
on the consent agenda are 2 reasonable grounds, proposed findings that there was no objection to. So we're proposing that those be on the consent, those be adopted by consent because there was no objection. So
Well,
all that
there's-
remains for hearing are the 3 no reasonable grounds findings.
Okay. Okay, the 2 that were reasonable grounds are not objected to.
Correct. And they're different respondents. The only respondents for
Right.
that are the school district and the high school.
And the school district did not respond then.
Correct.
Somewhat surprising, but I guess that's not relevant to me.
Nope.
Okay, thank you.
And commissioners, if I could just ask, when we're doing voting, we need to be doing voting by roll call again. We need to go back to that. And commissioners need to indicate their vote both orally, you need to speak it and also show it both ways. So just a reminder, I know it'll slow us back down, but we got to go back to that. So there's a motion, it's been seconded. Ed, did you second that? I'm not sure if you were
Yes, I
seconding
will.
or.
I will,
Okay.
yes.
So the motion to adopt the agenda and consent agenda, I'll go in order, commissioners. If you say yes, you're in favor of adopting the agenda and consent agenda as is. Commissioner Whitworth,
Yes,
got to put your hand up too.
yes,
Thank you. Commissioner Ashby,
Yes.
Commissioner David,
Yes,
Commissioner Dusan. Commissioner Dusan,
oh, sorry.
Jill,
not
Jill?
hearing you.
Commissioner Dusan. Now I'm messaging her. Commissioner Dusan? Do you have your volume turned up? Commissioner Dusan, can you hear me? Commissioner Dusan? Can you hear me?
I can't seem to. Oh,
I can hear you speaking. Turn up your speaker volume. Oh, now she's gone. All right, we can continue the vote on this and she can come back in. Commissioner O'Brien, yes or no to yes?
yes,
Okay, so that's 4-0. We'll get Commissioner Doosan back in a minute. Okay, go ahead, Commissioner Whitworth. Sorry about that.
Okay. The minutes of June 14th commission meeting, is there a motion to adopt or amend?
So moved.
Which, was that a motion to adopt?
To adopt. Sorry.
Second,
So commissioners,
There we go.
there's a motion and it's seconded. Is there any discussion? Jill, just so you know, we're just had a motion to adopt the meeting minutes from June 14th. Is there any discussion? And Commissioner Doosan, in case you couldn't hear me saying this before, we need to go back to voting by roll call, and each commissioner will need to vote showing their vote and also saying it. So at this point, commissioners, I'll ask each of you one by one. If you vote yes, then you're voting to adopt the minutes from the June meeting. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
yes,
Commissioner Doosan,
Yes.
Commissioner O'Brien. You are muted, but I saw you say yes.
Yes.
Thank you very much. Okay.
So moving on to the director's report. Amy, can you
Yes.
give us your report, please?
I will. So commissioners, you have from me a memo about personnel. We have a new front office staffer who's great. It's the first time we've had a full front office staff in a year and a half. It's delightful. And I can tell you, and I'll talk some more about the legislative session in new business, but I did want to mention it here, which is that the finalization and the signing of the biennial budget does impact some personnel matters for us. We thought we were going to have to cut our paralegal position to, we had cut it up in the curtailment, and it was supposed to be, our understanding was it was going to be carried forward forevermore. And in fact, that did not happen. So we get to keep that as a full-time position, which is great. We did finally get the investigator positions reclassified, something which some of you who've been here for a while, I know Deb has been here the whole time we've been trying to do this. We've been trying to get that position reclassified. And Jill probably remembers it from when she worked here. We've been trying to get it reclassified for a very long time. And it was approved 2 years ago, but it wasn't funded. And the funding to effectuate it was finally included in the governor's budget, which is great news. So I'm happy to talk about any of those details as needed about particular incumbents in positions in executive session. But in general, I'm happy to answer any questions about that. And Commissioner
Yeah.
David.
yeah, what's the significance? What's the reclassification?
That's right. So you weren't here. Almost none of you were here. For a very long time, the investigator position has been underclassified. So a classification in the state system recognizes the sophistication of the work, the independence of the work, the nature of the work, and its sophistication and discretion. And for a long time, and there's a ton of different characteristics that the state system looks at in determining how it should be classified, in what bargaining unit and what pay grade and steps and things like that. And this position had for probably, I don't remember now because I wrote the stuff so long ago, but it was probably 20 or 30 years, had been classified as a step 24 in the relevant bargaining unit. And it was really underpaid the investigators. And they left a lot for higher paying work. And they would all say it's because of the money. And so we kept submitting things to the state, trying to get the pay and the classification changed so we could increase the salary and we could keep the investigators who we train and who do a great job and who I think like working here. And 3 years ago, I think it was 3 years ago, maybe 4 years ago now. It must have been 4 years ago. We submitted documents. The commissioners approved, are again seeking a reclassification to increase it, to change the classification. And we did, and we changed it. It was a two-step So from 24 to 26, that's a big jump for investigators. Some of our investigators have been capped at the top range of 24 for a decade. And so this actually lets them earn somewhat of a competitive wage, and hopefully we can keep the fantastic investigators we have. It also more accurately recognizes the independence, discretion, and legal training, because we now require a JD. We don't require entry to the bar or anything like that, but we require, because our claims are really complicated, we require a JD, and this also properly compensates for that.
Thank you.
So that's personnel. And for I told you that. For compliance, there's a lot of post-reasonable grounds cases. Currently, there are 14 in progress, which is the most that I can remember in quite some time. Since the last meeting, we had 5 unsuccessful conciliations. We did have 1 successful conciliation that I need to ask you to approve the agreement. You have a memo from me regarding L. Barbary versus the Penobscot Company. And at this time, I would ask that you make a motion to approve that conciliation agreement.
I move approval of the conciliation agreement.
Second.
Okay. So it's been moved and seconded to approve the conciliation agreement. All those in favor, when I ask you, please say and signify yes. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
Yes.
Thank you very much. Next, we have for investigation. In June, we had 71 new charges, continuing to just see high numbers. I think that trend's going to continue for a while. Administrative dismissals in June, I dismissed 15 complaints administratively. That does not include right to sue letters or settlements. In June, there were 16 predetermination settlements, and I forgot to write down the amount of benefits to complainants, which I will tell you in a second, with benefits of $457,000 to complainants. For litigation, I would ask that we take that after executive session. And then for quarterly reports, I can tell you that for training and education in the quarter that was from April 1 to the end of June, commission staff attended or presented at 12 sessions, but I have to say that included within that was a tremendous amount of legislation, legislative hearings that Barbara and I and Melody were all attending because the budget was happening, and a ton of public hearings and work sessions on a lot of bills that had been proposed a while ago. So it was an extremely busy quarter. And I think I included copies of written testimony that I hadn't provided you before, so newer things. And I'll talk in a minute about one of those bills that we had public hearing and work session on was the commissions bill. So I'll talk about that in a second in new business. For pending inventory in this quarter, we had 732 cases pending. And settlements in the quarter, so predetermination settlements during the quarter there were 39, and I did not write down the number for overall relief, but I will look right now. And it was $1,023,000 in benefits during the quarter to complainants. So we've been busy. For new business, the bulk of what I have to, and Melody, I forgot to say, will send the financial report. She's sorry, it was not uploaded just yet, but we will send the quarterly financial report to you. And we're always happy to answer any questions you have about the financial report. For the legislature, so I mentioned the budget, and 2 things that were very significant for the commission, actually a lot of things that were really significant at the legislature. One was the passage and signing into law of the commission's bill 1688, and I sent you all a copy of that. There's a lot of changes in there. I'm not going to try to go over them all now. We've talked about them previously, I think. Really, everything that we had submitted in there went through. There were no substantive changes to 1688, which is great. It's the bill we proposed 2 years ago. So it's a relief to finally have that done. And we will be issuing both press releases and a lot of updated guidance and forms. Employment inquiry guide, housing inquiry guide. A lot of our pamphlets we will be changing, our online information, it will be a lot of work to update that. But also, 2 other things that we have found out. One thing that you already know is LD 32, which is a bill that no one seems to be talking about, which is strange since it impacts all state agency business like this. Talks about agency proceedings, public agency proceedings like commission meetings, and sets out rules for how they need to occur going forward in terms of remote participation. And it's because of that, which was signed into law in late June. It's for that reason, as of our August meeting, we will be meeting in person, which people have been talking about, wanting that for a long time. So that's number one, that's the default. And the commission no longer has the power to say that meetings will be held all remotely unless there's an emergency or other urgent situation. So we will be meeting in person in our building. We have a conference room up on the 3rd floor. And as long as we adopt a policy regarding remote participation, we are allowed to have commissioners participate remotely and the public participate remotely. That is why we quickly publicized a hearing for today and a policy regarding remote participation that covers all the things that LD 32 says we need to address. So we need to get a policy in place to govern our August meeting, which is why we're having a public hearing today. And we'll be happy to answer your questions about that. I thought we would basically move on to our hearing cases and take the rest of the new business, which is really just housekeeping after the few cases that we have to hear. So if that's okay with you, I would suggest that perhaps we go on at this point to the cases and take the rest of the new business after the hearing agenda.
Oh, okay, so moving on then. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and please introduce yourself as you are called for your case. Thank you.
And before we start, I would just remind folks to not mention the names of any individuals other than the parties. And in each of the investigators' reports, we've given pseudonyms to the people involved. So please use those. Thank you.
Okay, so our first case, E19-0323, Linda Small v. GOG Enterprises LLC, doing business as Subway Restaurants. This is partially a reasonable grounds case, so we will ask the respondent, GOG Enterprises, to present first. Is there anybody here for GOG Subway Restaurants? Okay.
So I'm kind of filling in for.
Hold on just a second.
Yeah.
Sorry, Mr. Galush, hold on.
That's okay.
I don't believe that respondent actually submitted anything opposing the reasonable grounds finding. I know they want to make a statement if complainant presents, but respondent didn't actually oppose the reasonable grounds finding. So arguably, they should not present in opposition to it at this point. Barbara, do you agree?
I do. I was looking for my unmute button when you started talking. So yeah, I think that the complainant should go first in this case since they're challenging the no reasonable grounds finding.
Thanks, Mr. Galush. We'll just mute you for now. So, Ms. Aiello.
Good morning, commissioners, commission staff, Mr. Galush. My client, Linda Small, is here. And Linda, if you want to turn off your camera, you're welcome to do so, but you can see her name on the screen there. Thank you for allowing us an opportunity to present today. The investigator erred in this case, in part because he found that there are no reasonable grounds to believe that respondent discriminated against Ms. Small when respondent failed to hire her. And we want to talk about that finding. I want to start by saying that Ms. Small worked as a sandwich artist for a respondent way back in 2006 through 2008. During that time, she received no negative evaluations. She was asked to work extra hours. She received raises, and she left on her own accord for another job that provided her with better hours for her young son's busy school and sports schedule. Ms. Small has a per se disability under the Maine Human Rights Act, an acquired brain injury from birth. Although her disability causes her to walk with a slight limp, it did not stop her from working her entire life, raising a family and being a very active part of her church and her community. So fast forward to 2019, her son is grown and Ms. Small was looking for work and inquiring with the general manager about working at Subway. The general manager encouraged her to submit an application when she asked about open positions. So in May of 2019, she actually did so and had an interview with the store manager regarding an open position at the Bangor Street location here in Augusta. So during the interview, the store manager asked Ms. Small, and Ms. Small discussed the requirements for the job, all of which Ms. Small was familiar with, of course, since she had done the job before. During that time, the store manager asked if there are there any accommodations we need to make for you, which is verbatim an example of a question that's prohibited under the Maine Human Rights Act. The store manager said in his statement that he made this statement and that was related to, quote, certified people with disabilities. Of course, in the Maine Human Rights Commission pre-employment guide, the Maine Human Rights Commission defines the following inquiry as illegal: whether an applicant needs a reasonable accommodation in order to perform a job. And of course, this is because the issue of whether or not there's a disability is not relevant at that stage unless the person is asking for accommodation. My client is someone who doesn't talk about her disability. She really wasn't asking for accommodation and it didn't come up except for that question. The investigator correctly recommended that there was a violation here of the Maine Human Rights Act when this inquiry was made. In any event, Ms. Small indicated that she would not require an accommodation. At the conclusion of the interview, the store manager found that Ms. Small was qualified. He was actually, according to my client, very enthusiastic about her starting. He gave her a uniform and told her she was scheduled to work the following day on June 1st, 2019. So just 2 hours before she would start her shift, the store manager called Ms. Small and told her the owner said that she's a do not hire. Therefore, the offer was rescinded and the shift was canceled. Ms. Small was shocked. She had a good work experience. As far as she was aware, these issues that were raised now about work performance were never raised to her. The general manager had suggested that she apply, so she was really taken aback by this. As you can imagine, you're given a uniform, you're told that you can start, you've worked there before, and suddenly you're told you're do not hire. So Ms. Small knew the owner, of course, from being in the same church community and working in the store before. He now lived out of state. But she actually told store manager, well, I don't understand this. Store manager didn't give her any more information. So she said she would give him a call to ask why the offer was rescinded. Now, this is a really important point in this case where Ms. Small called the owner. He answered the phone right away. she asked him point blank why he would not hire her. Ms. Small is a very direct person. So she asked him directly, can you tell me why? I don't understand why. And he said, it's because of your knee. I know you have problems. That's what he said to her. My client has been perfectly consistent all the way through this entire case, both from her sworn statement to her testimony, that this was what was said to her. The owner, it was clear to her, was referring to his observations of her gait, which is imbalanced because of her brain injury. Her knee problem was the only reason he gave her. So this was what my client had for information, direct evidence of discrimination. Although she walks with a slight limp, this has never prevented her from doing the essential functions of the job as sandwich artist. Now, this is significant legally because this constitutes direct evidence of discrimination. She was fully capable of doing the job, but the owner's wrong assumption that she could not limited her. It was not her disability that limited her. It was the attitude of someone else that limited her. So where direct evidence exists, complainant need only prove that the discriminatory action was a motivating factor in an adverse employment decision, not the motivating factor. So to the extent that the commission is concerned that there were performance issues, absolutely, someone could not be hired because there are past performance issues. This is not the case here. To the extent that there was more than one reason, the burden on my client is to show that it was a motivating factor. That's from Patton versus Walmart Stores East, the 2002 case from the First Circuit. So I would encourage the commission to take a second look at that recommendation and reverse it, because my client has shown that there was evidence, direct evidence of discrimination. Now, I do want to talk for a minute about what the employer says the reason was. The employer says, well, wait a minute, there were past performance issues. And as I've said before, and as I would always obviously say, that if there are problems with a past work performance and someone is being judged on their past work performance as being problematic, then that certainly would be a legitimate reason to not hire an individual. But the evidence here, since we've, both parties have met their burden, the evidence goes back to my client to say why it's pretextual to say that past work performance. And I talked about that a little bit in my in my response or my objections. First, the direct evidence because of your knee. Second, the owner never explained the problem was past work performance. Why wouldn't he have said, well, gee, I don't know that this is the best job for you. I have concerns about your ability to do the job. None of that came up on that phone call. It was only the knee issue. Third, Ms. Small worked at Subway for 17 months. She was never criticized for her work performance, and she never received a negative evaluation. She received hours and raises. She left on her own accord because a schedule with another employer was better for her son's schedule. Fourth, the owner admitted that he had noticed Ms. Small had a limp. And in the past, as the evidence showed, Ms. Smith was a church volunteer. And at that time, he had expressed to her concerns about her ability to do certain things like vacuuming and so on because of her knee. But again, it was not a problem for her. And I think, another reason that there's a pretext, I think my client can show pretext, is that the owner just lost credibility when he denied making the explicit statement about Ms. Small's knee. That was a direct statement made to her. She's been unequivocal about it. So for all of these reasons, I would encourage the commissioners to take a second look at that first recommended finding of no reasonable grounds. We think there was reasonable grounds there. We hope that you'll reconsider it. In any event, we agree with the investigator's finding or recommendation on the illegal inquiry, and we would ask that you affirm that and allow this case to go to conciliation. Thank you so much. I appreciate your time and happy to answer any questions.
Thank you, Ms. Aiello. Commissioners, I think what we'll do is if you have a question for Ms. Aiello, raise your hand and I will call on each of you. If you have a question at this point for Ms. Aiello, raise your hand. Okay, seeing just one, Commissioner Ashby. Oh, and then Commissioner David after that.
Ms. Aiello, is it an overstatement of the case to say that the case really does hinge upon whether we believe that the statement about the knee was made by the owner?
I think that's a huge factor, certainly, because that's the direct reason that she was given for the lack of hiring her.
Right, that's your direct evidence of discrimination, right?
That's right. I think also if there was no statement to that regard, you still could find reasonable grounds, because I think that my client has shown, then you go directly to the McDonnell Douglas evaluation. And I think my client would still be able to make a strong argument for why there are reasonable grounds. But the two combined, I think, really demonstrate the strength of the case, and at the very least, at least an even chance of prevailing standard.
Our investigator, though, considered and then seemed to reject that statement was made, right?
He did. He conducted interviews, and so certainly he did the work. He came to a different conclusion. We disagree with that conclusion.
I understand, and we, on findings of fact such as that, though, you agree we should give deference to our investigator?
I think you have an excellent paid staff at the commission. I think they very often get it right. We disagree with this recommendation, but I've sat in your seat before, and I understand the need to provide deference when there's been a direct inquiry. I think that the evidence that we've shown is convincing, and I would just ask you to take a second look.
Thank you very much.
Thank you.
Commissioner David?
Attorney Aiello, the investigator says that the decision not to hire was made by the general manager. Your argument turns very explicitly on saying it's the owner that made that decision, and the evidence that it was discriminatory is what he said. But as I understand it, and this is my question, is it correct that when she calls up the owner doesn't even know that that entry's been made in the computer to not rehire, or to not hire after her prior employment?
Yes, Commissioner David, that is what the owner indicated to the commission, that he had no idea. And when she called him, he didn't know about the hiring. He didn't know about the lack of, the issues. He did say it's because of your knee, though, which suggests something to the contrary. So I think we have a dispute of fact there, certainly. And the fact that the general manager said that my client was not a do not hire, suggests that it came from the owner, potentially suggests that it came from the owner, that potentially suggests that there are issues there with concern about unfounded concern about a disability. But as we all know in these cases, they're not always entirely clear, and you need to make your own judgments in terms of the facts, certainly.
Well, he says it's because of the relationship with the owner and because of the previous history. That's what the general manager says was the reason for making that entry, do not hire, which, as I understand it, was made after her prior separation from employment. It's a note in her personnel file. Is that right?
That's right, but there's some confusion in the facts where the store manager makes some inconsistent statements, like he looked up in the computer and it was a do not hire. And then, as I recall, and someone correct me if I'm wrong, but as I recall, it came out later that there was no actual computer notation about do not hire. So there's been some inconsistencies in what has been indicated by the respondent, which again goes to the issue of pretext.
Thank you.
Thank you very much.
Thank you. So now, I'm sorry, Commissioner Whitworth.
I don't know if this is in the record, so obviously don't answer it if it's not. But regarding the do not hire, is there any documentation in the personnel file relative to why there's a do not hire? Or is there just a note that says do not hire without any backup to it? Because being eligible for hire and not hiring are two different things.
Right. And Commissioner Whitworth, there was no personnel file that was ever produced in this case. So it's just the bald statements that I'm aware of in the records, because no file was ever produced. And there was a suggestion, as I recall, that there was nothing, that the store manager just said there was something in the computer, but it's not clear that there was. It was never backed up.
Thank you.
Thank you.
Commissioners, any further questions for Ms. Aiello at this point? Nope. Okay, thank you.
Thank you.
So Ms. Aiello, you'll have about a minute and a half left when we come back to you. Now, back to Mr. Galush. So Mr. Galush, you'll have 10 minutes. But you have to unmute. There you go. I'm not sure we heard that. Can you try one more time? Nope. Can't hear you. Nope. Microphone, input, output. I'm just saying words, Barbara, I know.
Are you just saying things you know?
I'm just saying computer-related terms to fill the silence.
It's like when something's wrong with the
Meeting
car. And I say,
now?
oh,
Yes,
yay.
now we got you. See, if I just say random words.
Awesome.
Yeah,
That
okay.
was just pure luck. I am not tech savvy at all.
None of us really are. As you can see. Okay, Mr. Galush, you have 10 minutes.
My name is Nathan Kaluch. I'm a partner in and the general manager of the local area subways. I'm reading the following statement in behalf of my partner, Jeff Owen, who was unable to participate today. Having been in the fast food industry for nearly 2 decades, I have come to understand the importance of having good employees. It defies reason for me to turn away a worker with Subway experience that was indeed a good worker. I know Miss Small quite well. We attended church together. I invited her to my home on a number of occasions, and I have also performed service at her home on numerous occasions. I have no personal issues with Miss Smalls. I hired Miss Small in 2006, knowing she walked with an uneven gait. That was never a consideration in the hiring process. When we returned looking for employment years later with the same uneven gait, she was not rehired, but it was not because of her gait. Choosing not to rehire her because prior to leaving Subway was solely past performance. It was her performance, not her gait, that precluded her from being rehired. There is no logical explanation, business reason, or otherwise not to rehire a friend who had demonstrated they were proficient in their work. Ms. Smalls was not considered by me, her supervisors, nor her peers to be proficient as an employee at Subway. Did I tell her she was horrible, slow employee that other employees did not get along with or want to work with? No, I did not. Did I hire her because she was not a good employee? Again, she was a friend. In the years following, there were several occasions, either at church or her visiting me at my office at Subway, when she would approach me inquiring whether or not I was looking for help. I would always politely dissuade her from again pursuing employment at Subway. Throughout her interview with investigator Milo, Miss Smalls had a very specific recollection of her work at Subway that was not most often accurate. On one such instance, when she was asked, "How did you get along with your coworkers?" Miss Small responded, "Everybody seemed to like to work with me and be glad that I show up." The following 2 statements were provided by employees who worked at the same location during the same time frame as Miss Smalls. Former employee Patrick Poulin stated,
Mr. Galush,
yes,
you can't use names, so just say it's a former employee.
sorry,
Is this something that the investigator has already seen?
Right.
that I'm not sure of.
The attorney for complainant is shaking her head as though she has not seen the statement that you're talking about. So if
Okay.
it's something that the investigator has not previously seen, you can't refer to it.
Okay. So I will skip those quotes by those other former employees. I apologize. So my own recollection of Miss Small is of her being extremely slow, complaining about other employees, frequently bypassing the chain of command, skipping the manager or the assistant manager, coming back to my office to complain about other employees. She knew she always had my ear. In her 17 months at Subway, Miss Small did receive a 25-cent raise, a minimum wage increase by 25 cents while she was there. Some employees would receive a 25-cent raise upon completion of online training. I did not recall the circumstances of her particular
Mr.
raise.
Galush? I'm
Yes.
sorry to interrupt. Complainants Council is indicating there's something you just mentioned about the other employees getting raises that was not previously shared with the investigator. Mr. Gitchos, is that accurate? Yes. So that information should not be considered by commissioners. And again, I know you're reading a statement someone else made, so please,
Yeah.
nobody's mad at you. It's just that there are rules about what can and can't be considered, which I did in fact share with Mr. Owen.
It would not be uncommon for good employees to receive multiple raises in a 17-month time frame, or receive raises much larger than 25 cents. When Ms. Small called on June 1st, 2019, asking what was going on due to the circumstances, she was understandably upset. However, I was not aware of any of the current events that transpired, and I could not give her the answer she was looking for. In closing, regarding the interview with the store manager, Adam Singleton, regarding the content of the interview with Ms. Small, he states that Ms. Small—
Mr. Galush, I'm
Yes.
really sorry to interrupt you again, and I know you're just reading the statement, but you're using people's names, and I know you're just reading it, but we can't refer to people's
Sorry.
individual names.
Sorry, yes.
It's okay.
All right, sorry. The store manager, regarding content of the interview with Ms. Small, he states that Ms. Small mentioned something regarding the text of being asked about being able to meet the job requirements. Quoting it from the record as submitted by Ms. Small's counsel. Ms. Small walks with an unsteady and uneven gait that is obvious. Now reading a short statement from the EEOC website regarding laws and guidance for applicants. It reads, may an employer ask applicants on an application form or during an interview whether they will need reasonable accommodation to perform the job? Generally, no. An employer cannot ask all applicants whether they would need reasonable accommodation to perform a job, because the answer to this question is likely to reveal whether an applicant has a disability. However, if the employer knows that the applicant has a disability and it is reasonable to question whether the disability might pose difficulties for the individual in performing a specific job task, then the employer may ask whether she would need a reasonable accommodation to perform that task. An employer might know that the applicant has a disability because it is obvious, or she has voluntarily revealed the existence of one. When asked to provide the context in which this question was asked, Ms. Smalls was unable to provide. While I do not dispute the question was asked, I do believe the store manager had Ms. Smalls' interest in mind. In his mind, he had hired Ms. Small and was merely offering accommodations if there were be any required. It was not his intention to discriminate against Ms. Smalls because of the disability. Thank you for your time, Jeff Owen. And I apologize for using the names that were on the statement from Jeff.
I understand. It trips everybody up. I do this repeatedly even for people who are at our meetings all the time. So thank you for that. So hold on just one second. Let me see. Any commissioners who have questions for respondent, raise your hand. I do not see any. Up, Commissioner David.
Do you know where that entry of do not rehire was made, or whether it actually was an entry in the file?
We typically have exit interviews. So when somebody gets done, we have what's called an exit interview, and we'll fill out if they're rehireable, why they left, and that's, pretty much it.
Do you know who made that
I
entry?
do not
and
know
whether-
if she has one on her file or not. No.
That's all.
Any other commissioners with questions for respondent at this time? Okay. Thank you, Mr. Galush. You have just over 2 minutes left if you want to use them, so just hang on. Back to Ms. Aiello. You have about a minute and just under a minute and a half.
Thank you. Just briefly, I would encourage the commissioners to consider the direct evidence that was made, the statement that was made by the owner. I would urge you to look at the fact that the standard here is a motivating factor, not the motivating factor. And again, complainant acknowledges if there's someone who doesn't have a good work history, an employer who owns a business says, making this judgment based on this person's work history, that is the legitimate reason. There are lots of reasons why this is called into question here. It's, for someone who's been in the industry for so long, it makes no sense why some of these issues wouldn't have been suggested to Ms. Small. She's in a very difficult position here where she has to listen to this in this setting after never being aware of it or told about it. After believing that she was certainly a valued employee, and after being told specifically that it was because of her knee. So, I would just encourage the commissioners to take a second look, and that's all I have. Thank you.
Thank you. Yes, follow-up questions for Ms. Aiello. I see you, Commissioner David. Hold on one second. Any other commissioners? Okay, Commissioner David.
Attorney Aiello, isn't it the owner who says to the investigator, even if he hadn't told the employee, isn't it the owner that says it was feeling of transgression on the personal relationship that caused him to think she was not a good employer? She would go around the chain of command. She would, walk into his office, that kind of thing. It's him that's saying that it's performance and transgressing on the friendship, is it not?
That is in the record, Commissioner. I think also in the record is the other reason, which is because of your knee. Had that statement not been made, it would have been certainly more challenging to show discrimination, although there were problems with the interview, certainly.
Any other questions for Ms. Aiello?
Sorry.
Oh, I was going to say she just disappeared. Any other questions for Ms. Aiello from commissioners? Seeing none. Okay, thank you, Ms. Aiello. Back to Mr. Galush. If you want to use them, you don't have to, but you have just over 2 minutes left, but you have to unmute. There you go. Do you have anything you want to add? Nope, we couldn't hear you. Whatever happened before happened again. So whatever you did before, do that again. I heard something, but it's very quiet. Out. It's better, but still very quiet. Same. I'll try saying words. Output. Input. Microphone. Speaker. Those are all the words I have.
Sorry.
We can hear you, but it's super quiet and I'm really concerned the commissioners won't be able to hear you. I'm out of words. Did you look at your audio in and out? What it's using? Stop laughing at me, Barbara. This is all I have to offer. Speakers, microphone. Wait, that was good. What just happened? No. That was promising. Yes.
Be better?
Yes.
All right.
2 minutes.
Hey, that's just to kind of recap and give my personal opinion. Jeff is probably one of the nicest guys you will
Now,
ever have.
If you could hold up. Number one, Jeff is not a party. So we're talking about respondent. If there's a name we
Okay.
gave him, whether it's manager, we're actually not hearing testimony about your opinions. We're talking about the record in the case and the applicable law.
Okay. I have nothing after all of that.
Well, you had a chance.
I
Considering
tried.
that you were just reading the statement, you're doing really pretty well.
And I was very shaky. So my apologies.
Okay, so any other follow-up questions for respondent at this time? Seeing none. Thank you, Mr. Galush. I'm going to mute you. We're not going to have to unmute you again, so
Okay.
just listen. Okay. Okay, to the investigator, Mr. Gitchos.
Good morning, commissioners. Good morning, executive director. My name is Milo Gitchos. I'm the investigator that was assigned to this case. I believe the report is really clear to kind of give just some background on the no reasonable grounds portion of the case. What I paid most attention to was the timeline of events. In that complainant did come in, applied for a position, was offered a position, and then when store manager contacted general manager to inform the general manager of this decision to hire, that's when the store manager found out that there were issues with complainant and that the offer should be rescinded. The next step was taken by complainant when she directly contacted the owner, and the owner was taken off guard. And in the record, through emails and phone conversations, it was clear that the owner was made aware of this occurrence after complainant had contacted him. And that series of events, I felt, also coincided with what the other statements from the owner were, that previously, while she was employed under him, any issues or any things she might come up with, she would take directly to him. And it was the personal nature of their relationship, as I understood it, which was giving owner pause in offering her a position. The second part where I found reasonable grounds, simply put, regardless of intention, a question was asked. And I saw it as a fairly black and white issue. Please let me know if you have any questions. I'm here to answer them.
Oh, okay. I was going to say, any commissioners with questions, raise your hand. I see Commissioner Whitworth and Commissioner David. Okay, we'll start with Commissioner Whitworth.
So as I'm looking in your recommendations here, and you say, respondent provided a legitimate non-discriminatory reason for its decision to rescind the offer of employment, and that complainant's relationship with the owner and previous work history made her ineligible for rehire. Yet Attorney Aiello told us that there was not actually a personnel file. So I'm wondering where, or if there's any documentation that indicates that this individual was ineligible for rehire, or if we're just taking it on the word of the individuals who were interviewed. Is there any written documentation?
There's no written documentation, but both sides do admit that they've had a very close friendship for more than 20 years. And if not just at church, but a very close personal relationship. So there is no denial that complainant would come to the owner, and owner did make statements during the investigation to the fact that he would have to field complaints from other personnel. None of that has been written down, but those were the statements made during the course of the investigation.
Okay, and then I'm sorry, then a follow-up question relative to her not being eligible for rehire. Was there ever any discipline given to this individual saying, you know, redirect, don't go right to the owner, you know, here's the chain of command, go to this person instead, talk to your general manager, talk to the store manager, anything in writing whatsoever, or are we just to make a decision based on conversations?
Nothing in writing whatsoever. There is not, as I understand it, the owner was attempting to handle things in-house,
Okay.
Given the nature of their relationship.
Thank you.
Next, we had Commissioner David.
Mitch, the crux of your decision seems to be on page 47B. The decision not to hire a complainant was made by general manager. General manager made the decision to rescind the offer based on general manager's knowledge of complainant's work history and her relationship to owner. Is that based? Well, I guess the question is, general manager has been around long enough to have known the relationship with the owner? Because that's years before, right?
Yes, that is true, Commissioner David. They had worked together for some years, and the general manager was aware of complaint prior to her application.
And the general manager is aware of her work history and her relationship to the owner, as well as his own experiences with her. He had direct experience with her?
The general manager did, as I understand, in a number of times and where complainant had requested to apply or would ask if there were opportunities at the location. But given the general manager's knowledge of the relationship between owner and complainant, did not want to hire for those reasons.
But you're comfortable in the conclusion that you state here that it's the general manager that's making the decision.
Yes,
I can see that the owner's blindsided by the phone call, but the general manager has made the decision, right?
yes.
Thank you.
Any other commissioner questions for Mr. Gitchos? Commissioner Dusan.
Just trying to make sure I'm following the string of communications. I particularly want to be clear. When the general manager communicated the decision to the store manager to rescind the hiring offer, had the general manager spoken with the owner prior to that about this hire?
No, Commissioner Dusan.
So the owner would not have it. There's kind of a separation as to whether the owner communicated his concerns this particular hire in the same timeline. You're saying the general manager was acting on prior knowledge over a long period of time, not necessarily a direct communication with the owner with regard to this particular hire in this time frame.
Yes, as I understand it, the general manager already had an awareness of complainant and from previous history. And the first time the owner became aware of the situation is when the owner was contacted by complainant, and then was later recontacted, or not recontacted, but contacted by the manager. That's when they had the discussion. But the history of the relationship was known to all.
I tried to follow that.
I'm very sorry. How can I clarify?
No. You're doing great. I just so much seems to hinge on the oral communication, since there's not documentation in the record. I want to be sure I understand what is in the record as to the timeline of communications.
So go ahead. I'm sorry.
Is the general manager who communicated to the store manager that there was an issue with this particular employee, and the general manager communicated that prior to having any conversation with the owner on this particular instance? You understand what I'm asking?
The general manager communicated to the store manager that okay.
Mm-hmm. And when he was communicating that, he had not, the conversation between the complainant and the owner either had happened or not happened, but the owner had not had a conversation with the general manager before he told the store manager that this person should not be hired.
Correct.
Thank you.
Okay, any further commissioner questions for the investigator? Seeing none. Okay, thank you, Milo. So at this point, we've heard from the parties and the investigator. At this point, we would need a motion or motions. There are two proposed findings. Again, there was no objection to the second proposed finding about the unlawful inquiry.
Well, I'll move that we take the first recommendation, and I'll move that we find that there's no reasonable grounds to believe that respondent unlawfully discriminated against complainant based on her disability, and that the complaint should be dismissed.
Second.
It's been moved and seconded. Is there any discussion?
I think Commissioner Dusant's questioning was absolutely critical, and it supports the investigator's conclusion that the general manager made this decision, and not on discriminatory illegal grounds. Even if owner improperly states what he thought might have been going on when the employee again improperly contacts the owner directly. So I think that, well, that's it.
Any other discussion, commissioners? Seeing none? Oh, yes, Commissioner Whitworth.
I'm really torn on this. This is a real challenge for me simply because of the lack of documentation. There's nothing. There's no personnel file. All we're doing is making a decision based on comments and conversations that people have had. But for an employer to say, I have nothing in writing, I have no personnel file, I have no discipline policy, I have no internal complaint process, I have no chain of command. How are employees to know what they're supposed to do if they don't have a guidebook, if they don't have any written rules? And that's why I'm having a challenge with this, because there's nothing in writing. To just say, well, we don't have personnel files, that's not okay with me. I'm having a real problem giving a pass to a company that doesn't have anything in writing. And consequently, I will vote against the motion.
Commissioner Doosan, yes.
Those comments give me pause, and I just went back around the circle in my head that I've been going around through this whole discussion. But the respondent here is accused of, is charged with discrimination based on disability by failing to hire. And though I think it sure would be easier if there were documentation of performance issues, if there were a record of performance, or if there was a record of some exit interview. But that's not what the respondent is charged with. Failure to have records. It's really bad management and bad operations. But I am persuaded by the investigator's report and balance of the issues, and I'll be voting in support of the no reasonable grounds.
Any other discussion from commissioners? Yes, Commissioner O'Brien.
Thank you. I still sometimes don't know what I'm allowed to ask, what I'm not allowed to ask, but along the same line, is it coincidentally that there was no personnel file on this employee, or is it standard procedure that there is nothing, there is no documentation? Am I allowed to ask that question?
At this point, we're kind of past asking questions to the parties or the investigator.
Okay.
Oh.
Oh, thank you. All right.
Oh, okay. Sorry. Was that all? Okay. Okay. Any other questions from, discussion from commissioners on the pending motion? Seeing none. So the motion is to find no reasonable grounds to believe that the respondent discriminated based on disability and failure to hire. If you say yes, that means you agree with the motion. So I'm going to poll the commissioners. Commissioner Whitworth, I need you to do signify your vote both orally and visually. Commissioner Whitworth?
No.
Okay. Maybe you can give a thumbs down. I don't know how you indicate. Yeah, thank you. Commissioner Ashby?
Yes.
Thank you. Commissioner David?
Yes.
Commissioner Doosan?
Yes.
Commissioner O'Brien? You are muted.
Yes.
Thank you. So the vote is 4-1, and that motion carries the no reasonable grounds finding on the first claim. So now we need a motion on the second claim.
I'll move that there are reasonable grounds to believe that respondent discriminated against complainant based on disability by making unlawful inquiry, and that this portion of the complaint should be conciliated in accordance with the act.
Is there a second?
Second.
So it's been moved and seconded. Is there any discussion? Seeing none. All those commissioners, I'm sorry, I got used to saying all those commissioners, can't do that anymore. Commissioners, when I call your name, please signify with a yes or a no how you vote on the pending motion to find reasonable grounds based on the unlawful inquiry. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
Yes.
Okay, so that's unanimous. So the second finding is reasonable grounds. The commission will send both parties a letter about the next step in the process. Thank you very much.
Thank you very much.
Deb, do you want to call the next case? I'm happy to do it. You can do
Sorry,
it.
I was muted.
Okay.
So our next case, E19-0425BC, Michelle McDonald, the Brewer School Department, Brewer High School, Ms. Brianne Pelletier, and Mr. Paul Wellman. Is there anybody here for the complainant?
Yeah, and just to be clear, the only portions of the case that we're hearing right now are the no reasonable grounds recommendations.
Understood. Attorney McHugh present for complainant.
Go ahead, Mr. McHugh.
Is this the start of the 10-minute portion?
I haven't even hit the button yet.
Okay, thank you. Well, good morning, commissioners. My name is Daniel McHugh, and I'm here today to represent Miss Michelle McDonald, complainant against Brewer High School, and Paul Wellman and Bree Pelletier. To lay the groundwork of the 5 recommendations listed on page 16 of the Commissioner's investigative report, counts 1 and 2 dealt with the discrimination and retaliation promulgated by the Brewer School District, but counts 3 and 4 address the same, but for the teachers Paul Wellman and Brianne Pelletier. Count 5 addresses the complainant's exercise and enjoyment of the rights granted under the MHRA, and the issues at discussion today are counts 3 through 5. We are asking the Commission to overturn counts 3 through 5, and we will address each of these issues in turn. First, as to counts 3 and 4, it is our position that it is illogical to find harassment in my client's favor on counts 1 and 2, but not to find the ringleaders of the harassment responsible in counts 3 and 4. In fact, in almost every negative thing that has been said or relayed in the record about Ms. McDonald can be traced back to either Bree Pelletier or Paul Wellman saying it first. Since at least 2017, when much of the harassment against complainant began, after she advocated that the Gender and Sexuality Alliance Club, the GSA, should be allowed in the yearbook, Ms. Pelletier responded that the GSA is merely a support group and, quote, does not do anything worth taking pictures of. In fact, for over 2 years before Ms. Pelletier and Mr. Wellman recruited 11 coworkers into signing a petition against complainant, alleging overzealous LGBTQ plus advocacy, complainant had been raising repeated concerns with the district's administration that Wellman was knowingly dead-naming students in his class, encouraging unsafe classroom discussions around trans issues, and also bullying specific students within the GSA. What was Mr. Wellman's response and Ms. Pelletier's response to these concerns when Ms. McDonald raised them with them? It was not to become more thoughtful leaders and educators. Instead, it was simply to spread lies and try to have Ms. McDonald removed. The ones that were the victims in all this were the students who weren't getting the education that they deserved, and Ms. McDonald had to fight on their behalf. As to a matter of law, in counts 3 and 4 of the report, the Commission misapplies the law of Furman v. Staples to find that individual employees cannot be held liable for employment discrimination as employers. The report specifically says the commission interprets section 4633 interference to require an individual discriminatory action outside their usual responsibilities. However, it is our position that harassment is discrimination and amounts to an acting outside of the scope of employment as a per se basis, meaning on its own accord. In fact, when Ms. Pelletier was asked in her interview why she decided to gather the signatures against complainant, she admitted that she had no personal incidents with complainant. Instead, she was simply standing up for others based on the stories that she had heard, the same stories that she went around to spread. Additionally, a meeting with Ms. Pelletier and the assistant principal at the time, Ms. Pelletier said to Ms. McDonald, "I just don't like you, and there's nothing you can do about it." She would go on to admit to not responding to her professional work emails. Similarly, it was Wellman's vendetta against complainant that caused him to rally against her, which is also not one of his usual responsibilities of teaching that Furman requires. Dissimilarly from Pelletier's interview, though, Wellman could not bring himself to admit that he had no legitimate basis for his claims. Instead, he stated two claims. It started with a Facebook post that the complainant had made, and two, her insistence that the GSA was not merely a support group. And with those arguments, I believe that both Wellman and Pelletier were acting outside the scope of their usual responsibilities, and I ask that counts 3 and 4 be overturned. And that leads me to count 5, the enjoyment of rights granted by the MHRA. With respect to the exercise and enjoyment of these rights, it helps to start by painting a picture of who Ms. McDonald was before the petition was filed against her. In the run-up to this petition, Ms. Pelletier and Mr. Wellman had been soliciting signatures for her removal, but before that, Ms. McDonald had been the curriculum leader in the English department for 7 years straight without complaint. Her creative writing classes were and still are one of the most popular. She holds a certificate of advanced study in literature and teaching of writing, which includes, as part of that certificate of advanced study, a master's degree in the art of teaching, and notably in this case, she is also the co-advisor of the GSA. Those are many accolades that she carries with her as a very respected teacher at Brewer High School. The fierce advocacy that Ms. McDonald had for her students in the GSA and all the students that she has is but the tough outer shell of who she is as an advocate. Underneath that, she is an individual who must try to work alongside others who clearly despise her for the views that she has. And doing so for the past several years has had a devastating impact on her well-being and ability to function at work. Not only has she been the subject of this behavior for years, but she was also admonished for it in a very public fashion without any meaningful amelioration by the employer, who simply seeks to limit the liability in this case. And that's not all. The report goes on to omit many things, because while the report did a fantastic job of trying to summarize all that was happening here, it wasn't possible to catch everything. And some of the most devastating things were left out of the record. The report omits a June 25th, 2019 letter written to the administration by another teacher in the school. The letter expresses the teacher's concerns regarding the current anti-LGBTQ environment. The following comments were reported to be made by the other faculty members. Notably, one faculty member said in reference to a close family member of Ms. McDonald, "I don't know how you know if your kid is transgender. If my kid wants to pretend to be a dog, I'm not going to feed it dog food. I'm supposed to call this omit name a boy now? I mean, I am shocked. What if it is just a phase? Do we have to go along with it? Or what if it's mental illness?" Those are the things that she was subjected to on a daily basis. Even Wellman himself told Ms. McDonald to her face, "LGBTQ persons are mutations of nature that do not occur in the natural world." And what is the Brewer School Department's response been to all these comments and this culture? Either nothing or directly supporting this bullying behavior and these viewpoints. Specifically, in the wake of all the foregoing, they have replaced Ms. McDonald with Ms. Pelletier as the curriculum leader. And then they tried to correct that action by forcing them to work together and then subsequently removing her again. And we're here today seeking some form of help or findings that this behavior is not to be tolerated. Because to be clear, there's been no admonishment or no adequate training that has occurred for either Wellman, Pelletier, or any of the other teachers at play here. And why else would this behavior continue for so long after if it wasn't accurately addressed? And lastly, as to my clear errors to the report, while it wasn't omitted, I believe that the report on page 8 does a good job of explaining everything that was alleged against Ms. McDonald, but then it fails to adequately emphasize the later corrections, such as on page 4, paragraph G of the report. Wellman provides, quote, that during his training, complainant talked back to a contracted professional who was providing communication training with the English department. Complainant told this contracted professional that she was wrong and bullied the presenter over the belief. She interrupted the presenter and was hostile. However, when the investigator followed up on this claim, the trainer said that she did not feel bullied by the complainant when she disagreed with her. Moreover, even if the complainant did challenge her, complainant was accurate and the trainer later corrected herself. In sum, this is not the case of one difficult employee as would be convenient for the Brewer School Department. Instead, this is a case of one advocate working within a culture of transphobia and harassment who refuses to back down to any bullying, despite a culture of gaslighting and marginalizing her complaints in an effort just to reduce their liability. So with that, Commissioners, I'll rest my case and open it up for questions.
Thank you, Mr. McHugh. Commissioner questions for Mr. McHugh. If you raise your hand and let me know if you have a question for him, commissioners. Yes, Commissioner David.
Attorney McHugh, I spent some time trying to figure out what the difference, looking at the recommendations on of the investigator. And what's before us now is 3, 4, and 5. I was trying to figure out what the difference was between 1 and 5. And the difference is that 1 is now a finding and has been adopted that there was unlawful discrimination based on sexual orientation, et cetera. And 5 is that there's interference. Am I correct that that's how 5 is different from 1?
My interpretation between 5 and 1 is that 5 requires more substantial interference with their rights of enjoyment under the MHRA, whereas
is your argument that there's interference, the reduction in responsibility from chair to co-chair of the curriculum committee?
That, in addition to the hostile work environment that she was subjected to, interfered with her rights of enjoyment, as well as the damages that have occurred psychologically in the wake of having to remain in this hostile work environment. Those are all rights that are afforded to her under the MHRA.
Isn't the hostile work environment 1? Isn't that what we've already found?
Right, but I think the difference is that it must rise to the level of interfering with her rights of enjoyment and within the Human Rights Act. Okay. And my argument is arguing for the severity of what occurred, that it does affect that enjoyment.
Another question, if you know, and if it's in the record, is there a difference in a stipend or compensation for being a co-chair of the committee as opposed to being the chair?
I'd have to ask my client. No, there is not a difference.
Thank you.
Thank you. Other commissioner questions for Mr. McHugh? Seeing none at the moment, Mr. McHugh, when we come back to you, you'll have about 20 seconds left.
Thank you.
Okay. So I'm going to mute you for now, and then we will go to Mr. Boucher.
Good morning. Thanks, Amy. Commissioners, it's nice to see you, even if it's in this forum. I will be very brief. This is and has been a difficult case, and I appreciate all the work that Jane has put into sorting through all of these facts. Today, the only issue is, as Amy pointed out, whether there are reasonable grounds for counts 3, 4, and 5. In this case, the law court has made it perfectly clear that there is no liability for supervisors. That liability flows to the employer. So there is no facts in this record, as I understand it, that would support the commissioner or the commission going beyond what the law court has already said. And as Commissioner David just pointed out with respect to number 5, that has already been dealt with in count 1. And in Ms. O'Reilly's report, both footnote 2 and 3 address both of these issues substantially with the legal background. And we would urge you to follow the investigator's recommendation.
Okay, just a second. Just writing down time. Questions for Mr. Boucher from commissioners? Seeing none. Mr. McHugh, would you like to use your 20 seconds?
Yes, thank you. I'd just like to point out, rebuttal, that the supervisors in this case are actually co-workers, not supervisors. And as the law court does say, Furman does have exceptions. And if you act outside the ordinary course or your usual responsibilities, that is one of them. Thank you.
Any follow-up questions for Mr. McHugh from commissioners? Seeing none. Mr. Boucher, I'll offer if you want them. You have about 8.5 minutes left if you want to use them.
I'm all set, Amy. Thank you very much.
Yeah. Okay, so then we would turn, I'm sorry, commissioners, any questions for Mr. Boucher before we move on to the investigator? Oh, yes, Commissioner David.
I'm sorry, Michael, who was it? Do you represent the school department?
Yes, we represent the Brewer School Department. And the way that this was filed, it was filed against the school department and the 2 individuals. We also represent the individuals as employees of the school department.
But you didn't file a written response, is that correct?
No, we have. We've responded and been here through the process. This has been going on for about 2 years now.
I'm
I think the
confused.
question,
Yes.
We did not
Barbara understands the thrust of my question.
you didn't object to the reasonable
response
grounds
to-
finding.
No, we did not. Or to Attorney McHugh's
Okay,
his 17-day, and only as the commission already noted, there were several facts included in that that are outside of the record, and I understand and I know that the commission will not take those into account. So.
Right.
I need to interrupt things because as part of the consent agenda, we've adopted the findings with regard to the school department, not with regard to individual counts, which means that we have technically already adopted the no reasonable grounds finding against the school department on the interference claim. So there's an issue there that I'm not quite sure how to deal with. I'm going to suggest, just because it's awkward, that you withdraw your findings as to the school department and then just vote to adopt them, since there was no objection to them, to 1 and 2. So I think we need to withdraw what we did on the consent agenda and then revote votes 1 and 2. The findings are unopposed, so you'll just find reasonable grounds, and then you can address 3, 4, and 5 as you should. Did that
Barbara,
make sense to anyone but me?
Well, can I ask, my understanding of what the vote was for the consent agenda with regard to this case was that it was on particular findings, not with respect to particular respondents. My understanding was that they were moving recommendations 1 and 2, not with regard to particular respondents.
Is that what it says on the consent? I don't have the consent agenda right in front of me, so.
Well, to be fair, what it says is specifically is against Brewer School Department and Brewer High School, and it has the little star that indicates reasonable grounds.
All right, let's go with that was an adoption of the reasonable grounds findings. And then we can do 3, 4, and 5.
Commissioners,
Unless anyone feels it's unclear, in which case we can unring the bell.
Commissioners, was that your understanding of what you were voting on with respect to the consent agenda, that it was the reasonable grounds findings only? I'm seeing nodding. Yes, thumbs up. Is there anyone in the commissioners who is not comfortable with that? I do not see any commissioners indicating that they are uncomfortable with that. Council, are you both comfortable with proceeding that way?
Yes.
No objection.
Okay. All right. Thank you.
I thought you meant me. Am I comfortable? Since it's
I
my
did
job.
not mean you. I meant the other council. My lawyer, are you comfortable proceeding
I
that?
say, but it's my job to make sure this stands up.
I know.
So I need to be okay with it. And based on all of these representations, that's fine.
Okay.
I will stop being so concerned about these procedural.
No, you should be. Somebody has to be. Okay. So where we are, if I recall, is we've heard from the parties' attorneys on 3, 4, and 5. Numbers 1 and 2 are already decided. So we were about to turn to the investigator, I think. Yes, Jane.
Good morning, commissioners. As Amy just said, my name is Jane O'Reilly. I was the investigator on this case. I don't have anything additional to add. I'm happy to discuss further my assessment of the facts in this case and why I didn't feel that the individuals could be held liable, or again, the legal analysis that I used.
Questions from commissioners for the investigator? I see Commissioner Dusan. Any other commissioners? Okay, Commissioner Dusan. Oh, usually we go in order of seniority, and I did just see Commissioner David throw a hand up. Commissioner David.
Looking at number 5, Jane, why isn't there interference in the actions around the decision of chair for the curriculum committee after 7 years of it being her responsibility?
So
why isn't that an interference?
My understanding of the interference claim, and Barbara can step in afterwards to assist, is that it rises to the level outside of what would normally be examined within a hostile work environment claim or a normal adverse action claim. So that removal of that position is a standard adverse action claim where the liability would fall on the employer, not on the employees who were involved in that, who may have been involved in that. In that case, neither individual respondent was involved in that decision. That was a decision that was made by the principal and the other administration of the school. And so that fell under a standard adverse action analysis and not an interference claim.
But recommendation 5 is that the school department interfered, and that's and or, so it would
Correct.
stand alone.
So the school department was held liable for those actions underneath the different analysis.
Okay.
Was the earlier findings.
And that's what I asked before, that's included in the hostile work environment.
Exactly. If the school department had gone above and beyond or engaged in other activities that were not within sort of standard employment decisions, that may have been an interference claim, but it fell under standard employment.
Yeah, such as, well, okay. Yeah.
Commissioner Dusan. You're muted. There you go.
My concerns are with finding number 5. And the finding with regard to Mr. Wellman and Ms. Pelletier regarding interference with enjoyment, exercise and enjoyment. And so I would like to I went back through the report. I'd like to understand, if you wouldn't mind, just a quick summary of how you felt, how you resolved that, the direct behavior of those 2 co-workers. Okay.
Certainly. So within a standard analysis of an employment situation, an employment discrimination claim, the way that Furman directs our analysis is that actions by the employees, co-workers, supervisors are imputed onto the employer. So in this case, the school department. If the individuals had acted outside of that scope. So in this case, The scope that I'm talking about are the discussions with these two individuals were generally about school issues during school hours, in their capacity and their relationship as coworkers, school employees. So that all was engaged within that area. The level of interference is a much higher standard in terms of the severity of the actions that these individuals would have had to undertake. And my understanding is that's what Attorney McHugh is arguing. These actions do rise to that level. My assessment of those, based on the facts that I have in my report, is that they do not, that they are within this they did create a hostile work environment as I found in my findings against the school, but those actions are still within a scope that would be imputed onto an employer, not directed or found for the individual to have liability for those actions. Does that answer your question?
It answers, yeah, it provides clarity on how you reached your conclusion, yes. And without asking you to specify what actions in particular you're thinking of, I think I have enough information to be able to figure out how I would vote on number 5. So thank you.
Any other commissioner questions for the investigator? Seeing none. Thank you, Jane. So commissioners, we've heard from the parties and the investigator, and at this point we would need a motion or motions on findings 3 through 5, recommended findings 3 through 5. Numbers 1 and 2 have already been decided as previously discussed. So you can take those. It might be simpler to take them separately, just because it sounds like some commissioners may want to discuss 3 and 4, but I leave that to you.
Well, I think 3 and 4 are a pair, and and ought to be taken separately from 5. So I'll move that we adopt the recommendation for 3 and 4, that there's no reasonable grounds to believe that the individuals discriminated unlawfully, and that those claims should be dismissed.
Second.
It's been moved and seconded. Is there discussion?
Well, I guess I'm relying on counsel's footnote, which is an essential part of the case, but it's a legal opinion that I'm being educated about. So that's my reason for following that advice. That the actions of those individuals did not was part of the hostile environment, but does not rise to the level of individual animus, I guess I would emphasize.
Is there other discussion from commissioners? Commissioner Doosan.
Yes, on these two, I understand the issue of discrimination and retaliation are attributed to the school leadership, and that is part of why there is a recommendation of no reasonable grounds. And I'm comfortable with these 2 recommendations.
Any other commissioner discussion on this motion? Seeing none. So the motion is to find no reasonable grounds on proposed findings 3 and 4 with regard to Paul Wellman and Brianna Pelletier. So when I call your name, please indicate either yes or no if you agree with the motion to find no reasonable grounds. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Doosan?
Yes.
Commissioner O'Brien, you're muted.
Yes.
Thank you. So that's 5-0. The findings for the 2 individuals are no reasonable grounds. So Now we just need a motion on number 5, finding number 5.
I'll move. There are no reasonable grounds to believe that respondent Brewer School Department and the individual respondents interfered with the complainant in the exercise or enjoyment of her rights under the Act, and that the claim should be dismissed in accordance with the Act.
Second.
So it's been moved and seconded. Is there any discussion for commissioners? Commissioner Doosan?
I think I would just say, without expecting to convince others, that where I am on this is that it is a little more than interpretation of legal principle. That mixed in here is an assessment of severity and whether the behavior of the respondents, all 3, well, 2 were outside the course of their usual responsibilities. I think there was definitely interference here. And I believe that based on the record that I've read, that there's definitely impact on enjoyment and on exercise and enjoyment of rights. And I understand that the decision on this is relatively close, and that our investigator has done another fantastic job. And there is a question as to whether the behavior, the interference by Mr. Wellman and Ms. Pelletier fits within an exception. I just think I'm not saying that I believe differently. On the investigator's conclusion, I'm saying that I believe there is a certainly the possibility that the complainant would prevail on this if she were in court. And so I'll be voting no. Is that right? Is that a double
Yes.
negative?
I think that's correct.
Yeah, that's where I land. It's a close one, but I think that there's certainly I'm hesitating over using the magic words. Better than even possibility. Someone remind me what the magic words are.
At least an even chance.
At least an even chance that the complainant might actually prevail on this if she were in the next forum.
Any other discussion from commissioners on the motion? Seeing none. So the motion is to find no reasonable grounds for interference against the 3, really any of the respondents. So if you agree, no reasonable grounds, you will vote yes, orally and with your hand. If you disagree and you think there should be reasonable grounds, you will vote no with a thumb down. So Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
I didn't see your hand. And
Yes.
you're frozen. There you go. Thank you. Commissioner David.
Yes.
Commissioner Doosan.
No.
Commissioner O'Brien.
Yes.
Thank you. So the vote is 4-1. The finding is no reasonable grounds. So the 3 cases that were heard, the 3 claims that were heard were all no reasonable grounds. The commission will be in touch with the Brewer School Department, Brewer High School respondents, and the complainant regarding the next steps. And all the parties will get a letter confirming today's votes.
Thank you.
And with that, we are
Thank you.
down to our last case on the hearing agenda.
Council.
Thank you for your time.
Thank you.
So we have a housing case,
Correct.
H21-0039AB, Andrea Sienna Dode v. Pine Hill Association and Michelle Bellino. Is there anybody here for the claimant, Andrea Sienna Dode?
There is somebody on here named Abby. That's the name that's on their box. I haven't seen them. I've sent them a message asking what case they're here for. I do not know the answer. Oh, Hello.
Sorry, I'm actually here with Ben, so I'm with Maine
Oh,
Properties.
okay.
So that's kind of why I've remained silent in the background and not to be seen. I've been multitasking here, but
No problem. Just making sure that the complainant is not here. Thank you.
yeah, I haven't seen her.
So our investigator, is indicating that they do not see the complainant on here.
Correct. It's my understanding that she said she wasn't going to show, so.
Okay. And so typically when the party opposing the finding is not present, typically the commissioners vote to adopt the recommended finding.
I'm ready to make a motion.
Great.
I move there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability or retaliated against her for engaging in MHRA protected activity, and that the complaint should be dismissed in accordance with the act.
Second.
I heard 2 seconds. Julie.
I defer.
Okay. So as a motion, it's been seconded. Is there any discussion from commissioners? Seeing none. If you are in favor of this finding of no reasonable grounds on both claims, commissioners, you will raise your hand and say yes when I call your name. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
Excellent. Thank you. So that finding is no reasonable grounds, and we will send parties and counsel a letter to that effect. Thank you very much for being here, Mr. McCall and Abby. And at this point, that's the end of our hearing agenda. So at this point, we would typically go into executive session. Do you all want to take a 5-minute break beforehand or just go right into executive session? I see nods for yes. Okay. 5-minute break. So come back at 10:23.
Amy,
Yes,
while we're waiting, can I ask a question?
of course you can.
The last case brought up the question that if they don't show, if the claimant does not show, and it's customary or whatever that it's voted to accept the report, correct? Does the complainant know that?
Nope.
Are they aware?
Nope.
Okay.
Just to be clear, it's whichever party opposes
Okay,
it.
yeah, right.
It could be a respondent too.
Okay.
No, we don't tell them that, but it does. I take that back. Our letter to them tells them that they have to, in order to make an objection, they have to submit something in writing. I don't think it says that if they do that and then don't show up, that we will adopt the recommended decision. It does not say that. It does say, no, it doesn't.
And is there a reason, or that's just how it is?
It's mostly just because the letters that we send include a lot of information about what they have to submit, when they can submit it, what it's allowed to include, where to send it, in what format to send it, what happens if they don't send it. I mean, it contains a lot, and I'm pretty sure 95% of people who get it do not read everything that's in there anyway.
Right.
So it's really just a matter of, too much information to include.
Okay, thank you.
Yeah.
But Amy, it does say that if they don't respond, the recommendation will be accepted.
Yes, it does.
Okay.
It tells them if they don't submit anything, we're going to adopt the
Right.
recommended decision.
Right.
That's my question. That was my question. So
It does say that.
okay, that's
Yes.
thank
And
you.
in this case, to be
Yeah.
fair, her written decision said she wasn't coming.
Yeah.
We always just err on the side of caution.
All right,
So, Barbara, just to be clear, there was a couple of things of new business that we didn't get to. Should we do those before going into executive session or after? Do you think it matters?
I don't think it matters as long as we do them in public session. Want to get them done first?
Yes.
Sure. Okay. So commissioners, the things that we did not get to from new business essentially was talking first, let me just get out of the way. We have our meeting schedule for 2022. And although we don't have to have you approve that, it's sort of just, we've done it for years. So you have a memo setting out the 2022 dates, and I would ask you to adopt that, and then we will publicize the dates and people will put it on their schedule. We've already reserved the conference room here at the commission for these dates. So if someone would be so kind as to make a motion to adopt that schedule, that would be great.
So moved.
Thank you.
It's been moved and seconded. Any discussion? Seeing none. All those in, oh, no, okay. Going to go one by one. Please signify yes with your hand and orally. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan.
Yes.
That's not funny. I have zero sense of humor about this sort of thing. Commissioner O'Brien.
Yes.
Okay. Thank you. So with that out of the way, we can go to the legislative stuff, which honestly is pretty significant. So I'll take our bill first. So there's our bill and another bill that I didn't even include in this packet because we didn't realize it was actually a possibility until after we submitted this stuff. So our bill was LD 1688, and it's a bill that we submitted 2 years ago to sort of an omnibus, just updating of the Maine Human Rights Act, because there were lots of things that were inconsistent. And it pretty much passed 2 years ago, but ended up dying on the governor's desk after a lot of back and forth. So we resubmitted it this time, and it passed in the same form that we submitted it in, which was fantastic. The only major changes are that it includes, so currently for employment purposes, well, let me back up. Familial status has been a protected class in housing only. And it has been understood to mean having minor children. And that's true in federal law as well. It arises out of the Federal Fair Housing Act. And in this bill, LD 1688, we actually added that as a protected class in employment. And it's essentially caregiver protection, which exists in many other states, because there's always been a loophole where sex discrimination was protected for women with caregiving responsibilities. And also disability protection existed for people taking care of people with a disability, but there was this loophole. So we also added to the definition of familial status if someone is caring for a dependent adult. So it's not meant to be my dad is not doing so well. It's if you have guardianship or conservatorship of an adult that you're caring for. So those things are now expanded, now broader in housing and employment. And those were the, other than that, it was mostly routine, just sort of tweaking, adding protected classes to education that should have been added 20 years ago. Most of the rest of the stuff, is there anything I'm forgetting that was substantive, Barbara, in 1688?
Did you say adding age to?
Oh, I didn't. I forgot that. So in age has been included in employment forever, but we always found it odd that it was not included as a protected class in public accommodations, because there's really no rationale that makes a lot of sense for being able to exclude people based on age in public accommodations if it's not something like a bar. So it's been added, and there was no objection. That's been added in public accommodations. And so those things are the only substantive changes. They'll become effective. The session hasn't actually ended sine die yet, so we don't actually know when it will become effective, 90 days after when the term ends. But also, yes, Commissioner David.
How does what you just said about adding age to housing affect retirement communities in which, that's specified?
So age has actually always been protected in housing, but there's an exception explicitly in the Fair Housing Act and the state MHRC for senior housing that fits within a certain definition. And there's 55 and over, 65 and over. And so all those retirement communities follow all those rules and are accepted.
Okay.
But so what I didn't include for you is another bill that was not our bill, a bill that has been proposed many, many times before and has never passed, to add, and the proposals in the past have been to add domestic violence as a protected category, a victim of domestic violence in employment or housing, and it's never passed because the issue has really always been, how do you define what's domestic violence? How do you define victim? And people always objected that it would be very hard for our agency to administer because it would be like a trial within a trial. So this session, a legislator proposed adding a very specific protected, it's not even a protected class. You know how whistleblower protection, that's not under the Human Rights Act and it's not a protected class, but it actually arises under Title 26, which is state labor law, but we are the enforcement agent and it's retaliation for someone being, what's unlawful is someone being retaliated against for taking some action in employment. So like that, what has now been added, and the governor signed it last week, is protection for a victim of domestic violence who has obtained a protection from abuse order, and it's in employment and housing. And Barbara worked with the sponsor to make it very defined. So it's not an interim order, it's a permanent order and it refers to the statute. So it's not like anybody, a neighbor, it's like a family member. And so the governor signed that into law last week. And it actually, because when it was proposed, we had to say, look, that's going to probably mean extra work for us. So we attached a fiscal note to it of an additional half investigator position, and they got that funded. So that's good news for us. It's good news for victims of domestic violence. So that's something new for us. And so we were waiting for that piece to find out what happened with that. The governor didn't sign it. It went into effect without her signing it. So there was no publicity on it.
Have you had those complaints being filed that you've had to reject?
I think so. Barbara, does that sound familiar?
Yeah, we've tried to get it DV as sort of a disparate impact on women. in housing in particular is when we see this come up a lot.
Yes.
But that only is helpful if you identify as female and can therefore claim that you're part of the impacted class. So we have had to reject them for other folks and in the workplace if we haven't been able to sort of shoehorn them into something else.
Well, it seems to me that it's an important expansion that employers can say, no, I don't want to deal with this domestic situation with your irate boyfriend coming to the workplace and all that kind of stuff.
That's exactly
And they do.
right.
So yeah, this is good stuff.
Yeah.
And it happens in housing too, where, and this is not a new phenomenon, where there's a dispute between two partners living together and one gets a PFA. Who do they let stay? Whoever makes more money. Oftentimes it's the person identifying as male. So it has been in the past addressed when possible as sex, and HUD is aware of this. This is a priority of theirs as well. So it is. I think it's a really good development. We did not take a position on the policy, but I think it's a good policy change. So we have to basically redraft all of our materials, all of our public guidance, our employment inquiry guides. So we were waiting for this one last thing to find out before we did it. So we're starting that work now. So that's,
Amy?
Yes.
When you just said, I think you just said that it has been narrowed to if they have a protection from abuse order. Did I hear that correctly?
Yes.
All right. And so generally those are for a finite period of time. So is it if they have one currently, if it goes beyond, if it's no longer in effect? I mean, how is that?
Those are really good questions.
Did you just say familial? Did you just say it's did you just say it's family members? Did you say
I'm going to punt it to Barbara.
Okay.
It's
Give you a
anything
much better answer.
It's anything that falls under the particular statute that we cited, and I don't have it right in front of me, but it's basically a permanent protection from abuse order.
Okay.
And I understand that permanent means different things when it comes to those, but the protection follows it. Obviously, you can't be discriminated against for either having the order or having had received the order. But obviously, as time passes, once the order is expired, it's going to be difficult to necessarily connect just like it is with a whistleblower claim or something. Proximity is going to be important.
I think the term you want, Barbara, is a final order.
It is the term I want. Thanks,
yeah.
Ed. Right. Sorry, it's not work I ever did. But so it's a final order because we thought it was important that there have been notice and an opportunity to be heard and a finding by the court, as opposed to the ex parte order you can just go in and get on your own, which was originally covered in the bill. Anyway, eventually it'll become too attenuated to be an actual cause, but it's really the initial period that we're going to be dealing with a lot, I think.
Thank you.
The second part of your question, Julie, I think was, did I say limited to family members? The specific reference is to the statute and whoever it authorizes to get a protection from abuse order in that particular action.
Okay.
But it is abuse and not harassment, so.
Oh, okay.
Yeah.
Okay.
So that's a big deal. Oh, I'm sorry. Did you say something?
No, that was a question I had also.
Okay.
Yeah.
Thank you.
So the other thing that happened in the legislature, and this leads into our next thing, is LD 32, which I mentioned in the beginning. There's been no announcement that we've seen from the governor's office about the need for agencies to adopt these policies, but normally if we were adopting a rule, there'd be a whole process for public notice and periods of time, but that doesn't apply to a policy. So we are very quickly holding this public hearing today. I see Beth Stouter has just joined us, 2 lawyers. I circulated this to the list of lawyers who frequently practice at the commission. about today. It's up on our website, and only 2 attorneys contacted me to get login information in case they want to give a comment. So I think after we do executive session, we should try to get to that policy. Both Barbara and I, by the way, EEOC's national conference for our agencies is today, tomorrow, and the next day. It starts at 11:30. So we're going to try to get through executive session pretty quickly. I don't think we have much. And then do the policy for remote participation. So with that, I would like to ask that one of the commissioners make a motion to go into executive session. But if you make it, we got to hear you, and you have to make it so.
I make a motion that we go into executive session.
Second.
Who is that? Deb. Okay. It's a motion to go into executive session. It's been seconded. Any discussion from commissioners? Seeing none. When I ask you if you are in favor of going into executive session, please indicate with a raised hand and a yes. If you're opposed, thumbs down and no. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
Okay. I am now theoretically going to move all of us and Barbara into executive session. Cross your fingers. Here we go. Oh, I have to join them. Okay. Good to know. Okay. So we are back in public session, and at this point, I think we are ready to hold the hearing. Wait, do we have all the commissioners?
We've lost Jill.
We've lost Jill and Julie.
Oh,
Maybe they had just didn't hit the button yet. Maybe they believed me when I said that I was ending the. Nope, you're muted, Deb.
They might have hit leave meeting because they were very close together.
Yeah, they
yeah,
are.
I worried about that too.
Okay, well, we still have a quorum and Jeff's pressed for time and so are we. So I think we can start the hearing and they're going to come back in. So at this point, we are convening a hearing on the proposed policy regarding remote participation in public proceedings of the Maine Human Rights Commission. Commissioners, oh, there's Jill Doosan. Okay. I think you accidentally left the meeting.
Julie and I were having difficulty finding the leave room tab.
I know.
The machine moved me by itself, and I think that hopefully will occur for Julie.
Yes.
Do you recommend, Amy, that we move, that we either move or don't move, but that we file a motion or that we make a motion regarding the policy and then open for discussion? Is that how you want to handle the
Barbara?
We could, or why don't we have Amy do the walkthrough of the policy first? We usually don't let the public speak. Once there's been a motion, that's just for you all to speak. Yes. So let's see if Attorney Stouter wants to speak also before you make the motion.
Good thinking. So this is a hearing regarding remote participation in public proceedings of the Maine Human Rights Commission. And we've given notice to the public of our intent to adopt a policy that provides for commissioners to attend meetings remotely in certain circumstances, and also for the public to attend commission meetings in, hello, Commissioner O'Brien. We are just introducing our hearing in certain settings. So the policy we have, the draft policy of which you have a copy, references the Freedom of Access Act. It defines the term remote methods, and all of these provisions are consistent with the requirements of the Freedom of Access Act, specifically those outlined in LD 32. Remote methods is defined telephonic or video technology allowing simultaneous reception of information, and includes other means that are necessary to provide reasonable accommodations to persons with a disability. It does not allow public proceedings to occur by text only or chat. It says that commissioners are expected to be present physically for public proceedings, except when it's not practicable, and the circumstances when it may not be practicable are outlined as they are in LD 32 to include 4 exceptions. The existence of an emergency or urgent issue that requires remote methods, illness, other physical condition, or temporary absence from Maine that may cause a commissioner to face significant difficulties traveling or attending a meeting. The significant distance a commissioner must travel to be physically present at a commission meeting in Augusta, or the area of the commission's jurisdiction, which could include geographic characteristics that impede or slow travel. When commissioners do fit into one of those categories and are participating by remote methods, the commission will provide the public with a meaningful opportunity to attend the proceedings, and also will provide reasonable accommodations to a person with a disability necessary to provide them access to the proceedings. The commission does not routinely at its meetings allow for an opportunity for public input, and so we are not required to do so if we're holding one of our proceedings remotely. If we do decide, like we are today, to allow public input, we need to provide an effective means of that communication in a remote meeting as well. The commission will not determine that public attendance at a public commission proceeding will be solely remote. So this is distinguishing how we've been doing things during the pandemic. We are only going to be allowed to do that going forward if there exists an emergency or urgent issue that requires the commission to meet by remote methods. That is the wording included in the statute. And when we do allow for remote participation by members of the public, there are certain requirements in LD 32, such as providing advance notice under the Freedom of Access Act about how a person can access the remote proceedings, and also identifying a physical location for the meetings, which will be our meeting spot in Augusta. A commissioner who participates in a public proceeding by remote methods is present for purposes of a quorum and voting, which is very important to us, so we don't lack a quorum. And as you've seen this morning, we are required going forward by LD 32 to take a roll call vote for all votes and to make sure that voting can be seen and heard if using video technology. And the commission will make all documents and other materials it considers available electronically or otherwise in the same way that we do for an in-person meeting, to the extent customarily available to the public who attend commission meetings in person, as long as additional costs are not incurred. What that has meant in the past is that we provide an agenda to the parties. When we meet in person, we make a copy that's available to anyone coming in. We do that now by having it available on our website. So that is the draft proposal you have before you. And I did circulate notice to the attorneys who regularly practice at the commission, and it's posted on our website. And I only see one person logged in here. Attorney Stouter, did you want to present comments on the proposed policy or on the policy that the commission may adopt?
Well, we were looking at it in our office, Director Snooze, and we were just trying to figure out something about what it meant. And I think having remote access has actually been helpful in a lot of ways. And I think based on your summary and what we read, it sounds like the only remote access going forward would be if one or more of the commissioners had to participate remotely.
That is all that's required under LD 32. Mm-hmm. We're not required to provide remote participation except if a commissioner is going to participate remotely. But what it also means is that if we're going to allow commissioners to attend remotely, we have to have a policy. So that's why we're doing this. It is our intent to continue live streaming our meetings, and it's our intent to continue having Zoom participation available. I think a number of our staff may want to present that way. We will be doing hybrid meetings, having in-person meetings here in Augusta that we are also operating by Zoom and by live stream.
Okay.
That's our current intent.
That really answers my question. We liked having the option of participating remotely. We liked having the option of, if I have a client who's a representative of a respondent but is not going to be testifying, be able to listen in remotely from New Jersey or wherever they are. And it sounds like those things would still be available.
That is our intent.
That would be great.
So thank you, Beth. I only had one other attorney contact me seeking login information, and they are not on here. So commissioners, I don't believe we are required to hold the meeting open for any period of time. So unless there are things, commissioners, that you want to discuss, I think we could have a motion to adopt this policy if you are prepared to do that.
Actually, Attorney Stouter's question brings up a question in my mind, if you don't mind, and maybe I'm just dense, but I looked at this a second time based on her question. The policy says that the commission may allow members of the public or require them to attend remotely. And then as to commissioners, there are specific rules that the default is that we need to attend in person unless. And then what's included in the unless is the existence of an emergency or urgent issue, which I think is probably the argument that we would make as to why we've been participating remotely through the pandemic. But I will note that the declaration of emergency no longer exists, although there are state mandates currently that require rules regarding in-person meetings. Are we, let's assume we choose in August to attend remotely. Would it be under section C1 that there's an emergency or other urgent issue that requires us to attend by remote means?
The entire commission cannot choose. So one of the things that this says is that the commission cannot determine. So if you look at F, provision F,
yes,
the commission will not determine that public assistance at a public commission meeting will be limited solely to remote methods, except if there's an emergency or urgent issue. So we cannot cancel in-person meetings unless there's a state of emergency.
okay. So I think that suggests then that our days of having all remote meetings are over.
Yes.
Which is sort of what, it's a discussion that's been ongoing with the commission. I just want to make sure I got the finest point on it. All right.
Yes.
Thank you.
Since we are required at this point to have in-person meetings, we want to have a policy in place for if someone needs to attend remotely.
Got it. I understand that. Thank you.
Yep. Any other discussion among commissioners? If not, I would ask that a commissioner make a motion to adopt this policy effective immediately.
I'll move adoption of the policy effective immediately.
Second.
It's been moved and seconded. Is there any discussion? Seeing none. All those commissioners, one by one, if you are in favor of adopting this policy regarding remote participation in public proceedings of the Maine Human Rights Commission, please indicate that by raising your hand and saying yes when I call on you. Commissioner Whitworth.
Yes.
Oh, I forgot to say, if you're not in favor, indicate it by saying no and with a thumbs down. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan. Commissioner, I didn't hear you, Commissioner Doosan.
She's muted.
I know.
Sorry, courtesy, turn it off and then forgot to turn it on. Yes.
So under this policy, it's going to be important because I have to be able to hear it for people who are attending only by audio. Commissioner O'Brien.
Yes.
Okay, so with that, the policy is adopted effective immediately and will be in place for the August meeting. We will circulate that finalized policy to all of the attorneys who regularly appear, and we'll post it on our website and send a copy of it with our notice. And with that, I think we can end the hearing and our commissioner meeting. Is that accurate, Barbara? Yeah.
Move to adjourn.
I love it. We don't even need one. But he made one. Is there a second?
Second.
Okay. Well then, all those in favor?
One by one.
Commissioner. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
Okay, we're adjourned.
Next time Deb just gavels us adjourned.
Yep.
Adjourned.
No more motions. Thank you all.
Thank you.
See you in August.
Bye, everyone.
Bye-bye.